Hello, my name is Paul Garver. I'm an attorney with Habecker and Garver. I practice in the areas of estate planning and real estate. Today is the first recording in our 10-part series on our common estate planning mistakes, and today we're going to be talking about the misuse or the inappropriate use of jointly held property as an estate planning technique. Let's start this by illustrating or taking a situation so that we can illustrate some points. We have a older mother, let's say. Her husband has passed and she has 3 children, 2 of which are out of state, 1 of which is in state. We're going to call the girl in state Susie. That way we got some ease of use here. So we have Mom and Susie. Mom has been concerned about a number of things. First of all, Mom has had some difficulty taking care of herself, getting out of the house, paying bills, managing money, those types of things. It's been a little overwhelming for Mom. And Mom is also a little bit worried about probate. She's heard about probate and understands that's going to cost some money, and is worried about that for her children. So in response, what Mom has done is deeded the house that her and her husband had owned, and now just her because her husband has passed, has deeded Susie onto that property as a joint tenant. That way it passes directly to Susie after death. And then also has put Susie on as a joint account holder on both her checking and savings. And when talking to Mom, Mom has stated that don't worry, Susie knows what to do, and Susie knows what to do with that. Now, I've often found that Susie may or may not know what to do or what Mom's intentions are. Mom may have never even spoken to Susie about what it is that Mom wants Susie to do. But what we find is that at Mom's death, what really happens here is that Susie becomes the sole owner of those assets, both the property, the home, and the accounts that Mom had. So regardless of whether Mom had a will that stated that all 3 kids are supposed to share in the proceeds of the estate, or regardless of whether or not Mom had a will or a trust that specifically names those accounts and that property, really what takes precedent is the ownership. Regardless of what you do, the case law has upheld that is supposed to be regarded as the true intention here. That whatever is the joint ownership is, they're going to have it. Now, there's some other problems that Mom might have created, but we'll get to those in one sec. Let's finish with this one. This is a kind of a source then for some sore spot between Susie and her brothers and sisters who are out of state and are going to have some issues. And Susie may or may not know what to do, or may or may not try to split the proceeds from the sale of the house with her siblings, or utilize the money that's left over in the account after paying for Mom's funeral and all that. May or may not choose to split that money up. As a matter of fact, Susie may not even decide to use any of that money to pay for Mom's funeral, since she's a joint account holder. It's all up to Susie at that point in time. Also, something that we should be concerned about here, and something that should be discussed, and let me preface this by saying that I'm not an accountant nor am I a CPA, but we may have, and you should consult with an accountant or CPA about this if this might be an issue, but we may have created a taxable event during the life of Mother for Susie, because it's technically a gift. Mom has deeded Susie onto the property and thereby gifted her interest in the property. And that's something that might have to be unwound as well and might have to be dealt with. How would you avoid all this and still do what Mom wants, which is to avoid probate? Well, you would utilize a living trust, and you would put the ownership of those accounts and of the house into the name of the trust. But that's going to be handled in some later videos and blogs that we post, so that you can take a quick look and educate yourself on that as well. Last but not least, let's say that Mom and Dad had a substantial estate, and by estate we mean all the assets of Mom and Dad, life insurance, IRAs, 401ks, the home, all those types of things. Let's say they have an estate of $2 million. I'm recording this in February, beginning of February in 2010. Right now, Congress has not taken some action on the estate tax. The estate tax in this year, in 2010, it's repealed for this year, so it's unlimited. There is no estate tax this year. for people that die this year. Next year, it reverts back to $1 million, barring Congress taking any kind of action. And whatever the amount is set at, this illustration could still apply. You just have to substitute in the amount that Congress enacts. So let's say mom and dad have $2 million. Dad passes, all the estates are held jointly by mom and dad. Dad passes, mom passes, that $2 million then passes to the children. 1 million of that will be excluded from estate tax, and then the rest is subject to estate tax. So it's kind of convenient in our example here. 1 million is excluded, and the other million is subject, since it's 2 million. And that extra 1 million is subject to a 55% estate tax. Now remember, this includes life insurance and everything. So sometimes people feel like they don't qualify until they really start sitting down and doing the numbers. So that would be $550,000 in estate tax next year that would pass to the government, as opposed to the children. Well, by doing a living trust with some estate tax planning options, what we could do is set it up so that at the end of Dad's life, when Dad passes, $1 million, we could use his estate tax exclusion amount, which both the mother and father do have an estate tax exclusion amount. In the prior example, where we don't have a trust but it all just passes to mom, there's an unlimited marital deduction. So an unlimited amount can pass between mother and father without an estate tax problem. You only get the estate tax problem when it passes to the children. So in this example, what we do is we take that $1 million, Dad has passed, so we take that $1 million from Dad and we set it aside in a non-marital trust. That trust can be utilized by mom for her health, maintenance, well-being, buy food, do all those types of things that need to be done. And then she would have the other $1 million that they have in their estate solely in her name. And mom's passing, that money in the $1 million non-marital trust would pass to the children. And then the $1 million that mom has would then pass to the children as well, getting the full $2 million to the kids and avoiding the $550,000 of estate tax that we discussed earlier in our example. Now, these exclusion amounts may change. We don't know yet. Congress still hasn't taken action on it. We hope to see some action in the future, and we'll be posting on that here if something is done. So thanks for listening, and tune in next week for our next installment.